we're talking mostly about what is a court and how does a court work, and what is a judge and what does a judge do. And then we thought, like, as a third, right? So you've got three questions. One is the technicalities, the other one is the values, and then the third one is, what does it do to the system? How would the system have to change, human rights systems, to incorporate the use of these algorithms into the processes? So I'll tackle each one of those sort of step by step. But I really want you to stop me, like, or just raise your hand or just say it out loud if you've got things that you want clarified, or where I'm not being specific enough, where it's unclear. So let's have it like as a conversation. So has any one of you taken a complaint to the European Court of Human Rights? No? Would you know how to do it?
You have to send like by post.
Very good. You have to send it by post. Now, do you know if you need to type it up or if you can send it in written form?
It's written form, right?
So the court has a PDF file, right, that you need to fill out, ideally on a computer. Mm-hmm. And then you print that out, you type it on a computer, you print it out. You cannot email it. Yeah? You send it off to the court. And so your application, you saying a country has violated my human right, a country has tortured me, goes to the court on paper, guys. Yeah? Mm-hmm. Not in electronic form, but on paper. In specific situation where a person doesn't have a computer, they're allowed to submit it in this kind of form, yeah? Which means with a stylo, right? Instead of on a computer. So if you think about, could we use an algorithm in the court? There's like this first thing that I described about how applications get there is already a problem. Why? Why would you say it's already a problem?
Because you have to put all the information written like into the computer.
You have to put all the information that's written into the computer. And presently, this is done by humans, by people.
It can get lost.
Sorry?
It can get lost on paper.
It can get lost, right? But it's done by humans. Right? So you have people, you have lawyers, like I used to be, this was 20 years ago, like, you know, at the court where we would type in things that came on paper. Now, you're in your generation, you probably think this is totally stupid, which in some ways it totally is, right? That we're still in an age of email, in age of forms, like Google Forms, we're still sending things by paper, and then there's somebody who's putting them in, typing them up, right? And so the first way that AI could be used, it's something we called content capture. Do you know what content capture is? So when you scan a document, what is Google able to do? Or like, you know, you've got lots of things on internet that are able to do.
Read the text.
And what do they do? Yes, they read the text, and what do they do?
Classify.
Essentially, they turn it, like if you use an iPad, it can turn your writing into typed words. So what it does is it can read this and turn it into typed text, right? And so what we call that is essentially turns text to data. So it captures what you said, turns those letters into words, and that then an algorithm can analyze. That is the first way that an algorithm can be used in the court, both here in Strasbourg and in Geneva. I should say that Geneva has now changed the way that they accept these applications, and they actually have a form you can fill out online to tell you. So that's technically the first way. And do you see any issues with that one? What would you say? Like with AI reading your writing, maybe it's prettier than mine. But
You can be confused.
sorry?
You can confuse some words.
It can confuse some words, yes. Some letters.
Yeah.
Letters, okay, yes. Anything else? Beyond that? Do you see any issues?
Yeah, maybe safety issues related to your
Data
yeah, data protection, like your information potentially be shared where you wouldn't expect them to be.
Yeah, I mean, that's the case anyway. But in terms of transferring this into text, so you said, yes, maybe it reads an R as an A or something like that, but we can fix that. You know, we can teach it. We can teach it that. So in principle, this shouldn't be a problem, okay? Because today, this content capture process is about 99.9% reliable, yeah? And so it does a good job. So computers can read documents for us. So that's number one. Number two way that courts could use AI is through translation and summarization. Do you guys use any of that in your lives? Yeah. What do you use? I've heard an of course. So what is it you use?
Like some apps to translate or
Yeah.
like even ChatGPT, like
Yeah, good. And to some, yeah.
It is good to write a mail, to structure your text.
Very
and
good.
Summarize and compact what you want to say and just giving instruction to
Very good. Yeah. So this would be a second thing, right? So the court receives a lot of documents. Any court, right? A lot of documents, the application, but then a lot of supporting evidence. And what an AI could do is, you need to keep in mind this court works in 46, 40, 42 languages, right? So it's a lot. And actually the Council of Europe pays a lot of money for translators. And so this could all be shrunk by using these translation methods. And actually treaty bodies in Geneva already do use translation methods where a software translates what the person has sent to the individual decision maker. Or it summarizes. Any issues with that, would you say? Given you all use translation, have you noticed any problems yet?
But maybe on the logistical aspect, like the translator can lose their job because we're using AI.
So we're going to leave, I agree with you totally. We're going to leave the losing of the jobs aside because that's going to happen whatever. Like the moment we talk about AI, it's going to happen. Yeah, so people are going to have to find, they're going to have to be reskilled, right? But any problems with translation with an AI? Anyone?
it can miss some human part.
Yes, it can miss some nuances in language. Anything else? So what we found, Geneva uses a very specific program. I've forgotten now how it's called. So it doesn't use Google Translate, it uses a different one. And the problem with applications where you're writing human rights complaints is that they're very emotional. Yeah? People are talking about how they were tortured. They're talking about how they were mistreated. They're talking about how that made them feel. And what translation tools do is they usually level that, right? So when you have a lot of emotions, software will kill that emotion. And so the danger in that translation is that it will come through much more subdued. Yes, much more kind of lower level emotion. You'll just know the facts. It means that it will speak to the judge or the registry staff in a much less intense way. Yeah? You know how when you read text, you can connect to the text? Well, if a translation tool, like think about when you use ChatGPT, how does that make you feel, that text?
Yeah, sometimes we have to tell him, like, do it more
Humanized.
Yeah.
Humanize it, right? So what do you mean?
Like a 20 years
When you say humanize it, what do you mean? Like, what is it you're looking for?
emotion.
You're looking for something, right? It's like it just cuts, like it's just so level. It's also like on a certain level boring. Like it's also samey, right? And human rights applications are not. Human rights applications, when you read them in the original, is people who are very upset, people who have waited for years for justice, Like think about Navalny in prison, right? These are very serious violations. And so the danger of translation is really to cut that emotion. So that would be the first two uses. The other uses of AI that we sort of think about is then we go a step further. Let's say that these two are uncontroversial, even though I've identified problems, yeah? Then we have AI used to identify similar cases, to put them together. It's what we call clustering of cases. And that would be really useful, both in Geneva and in the European Court of Human Rights, because both institutions receive thousands of complaints. A lot of these complaints look the same, are very similar, but they might go to different people. Yeah? And if you had an algorithm, a software that would say, oh, these are exactly the same, or these talk about the same event, or they, then that would be really great to have these batched together or to go to the same person, and then you could render one judgment or consistent judgments, right? Because if you have them go to different people, they don't even realize they're all dealing with the same thing. So it's what we call clustering of similar cases, either by country or by specific area, by specific event, by specific article, by complexity. Let's say you wanted very, very complex cases to go to the lawyers who've been there for 20, 30 years rather than lawyers who've been there for 6 months. So those kind of things that an algorithm could do by reading the documents, by reading the application. Then a similar thing that would go a step further would be what we call a decision tree algorithm. And a decision tree algorithm essentially, like if you think about some of the questions that the courts answer are yes or no. So has this application been filed in 3 months since the last decision? That's a yes or no answer, right? Mm-hmm. And what the person now working at the court has to do is they need to look at one date, deduct the other date, and calculate, is this 3 months? Mm-hmm. You could have a computer do that, right? They could look at when was the last decision, when did they file, is it 3 months? That can be done by a computer. So that's one. So there are decisions that are made. If this is the case, then this is the case, it's inadmissible, etc., etc. Those kind of decisions we can put in a decision tree and an algorithm can make it. Yeah? Does that make sense?
Yes. On the admissibility process?
Yes, on the admissibility. And the big question for me and Larry was, what about on the violation, right? Mm-hmm. So on admissibility, is it 3 months? Is it 6 months? Has the person exhausted remedies? That's a yes or a no. But then we came to, what about the violation? And there we kind of went like, right? Is there a violation? So has a person been tortured? Is the severity of that of the treatment such that this is a really bad thing? And there we had a dilemma. And we had a dilemma because we noted that this is not the same situation as before. When you discuss a violation, has a state misused its power? Have they violated our private life, etc., etc.? The problem there is that you get into the process of discretion, right? Of what judges decide. So has the state misused its margin of appreciation, etc., etc.? And so on the judicial decision on whether there's been a violation or no, we say you probably don't want an algorithm deciding that, yeah? Mm-hmm. But you might be okay with the algorithm calculating how much this person should get in damages. Once you've already said, yes, there has been a violation, now how much do they get in compensation? That could be done by an Excel spreadsheet. Mm-hmm. Yeah? Mm-hmm. Does that make sense? Mm-hmm. So we are essentially trying to think about the process of adjudication and breaking it into small decisions that judges make and say which one of these decisions can be made by an algorithm and which ones are so special that they need to be protected. And the simple ones are yes or no deadline, yes or no exhaustion of domestic remedies. The complicated ones are degree of treatment, severity of treatment, maybe proportionality analysis, yeah? Are there other means available, et cetera, et cetera. Calculating damages, that's an easy one, et cetera, et cetera. And the other thing we find that the algorithm could also help in is do research. Now, at the moment, you need to know that ChatGPT, Gemini are shit at doing research, yeah? They're really not good at doing research. So we're not in a good place in terms of that. But if we improve these big models, what they may be able to do with time is identify relevant case law for us and say, this is the concept you should think about in this case. So look at the application and say, this looks like it's about this. If I look at cases that are about this, these might be the relevant precedents you should look at as the decision maker. At the moment, as I said, we're not there. Like the large language models are not. But, you know, there's a lot of us working on this. So hopefully in the next few years. So these are the types of things we've been thinking about. Any questions like on that technical stuff? Like any ideas you have?
Maybe I have a question about exhaustion of domestic remedies.
Yes.
You know, it's a very
Yes.
huge question.
Yes.
About 46 countries different, you know.
Yes.
Even in each country there
Yeah.
are long discussions about
Yes.
it has already been done or not, you know.
Yeah.
Is there a way, do we have a way for artificial intelligence to intervene in this point?
So a lot of these algorithms, especially on exhaustion or admissibility, would need to be country specific. So for example, Russia will have different things you need to exhaust or not exhaust compared to France, right? So they would need to essentially have a decision tree. Have they gone to the Cour de Cassation but not Conseil d'Etat, right? Those kind of things would need to be in. But we also say that anytime the European Court of Human Rights changes its case law and says, actually, you need to go to this additional place, we would need to fix the algorithm, go back to the algorithm and tell it that the case law has changed and that therefore the equation now is different. So you can't let the algorithm live on its own. Somebody needs to constantly interact with it and change it and fix it, yeah? And when I say somebody, I don't mean a computer coder. I mean a human rights expert, right, that is assisted by a coder on fixing it. But it needs to be a living instrument, right? Because if algorithm just lives in the past, we're not moving anywhere. So that is really important. But you're totally right that country specific, like in some sense, we think of the European Court of Human Rights or Geneva as these international systems, but certain questions are totally domestic. And so for those questions, the algorithms need to be drawn from the domestic, like on that interaction. Yeah, exactly. Okay, any other thoughts, ideas? Yeah.
I was curious maybe about the involvement of the private actors that are behind specific softwares or algorithms.
Yeah.
Like, what is their role, or in which extent they might be able to influence a path within the institution?
Super. So first of all, fantastic question. First of all, none of this has been done either for the court or for Geneva, yeah? And it's important to underline that, to say that the field is open, right? People can come in. I think it's from this point onwards that then decisions can be made. From my perspective, as somebody who studies the court and who believes in transparency, I think this needs to be open source. It cannot be a private company coming in. I think it would be very difficult, and you know, there will be discussion tomorrow, but there's also discussion more generally at the court that they need to work with academics, not with private companies. Because the moment you've got a private company in, you've got like this is an intellectual property exercise, and you totally depend on them, and then they may have biases, they may have interests, they may be influenced by states about how things should end up. Given you don't know how an algorithm is developed, what is fed into it, those are all very tricky things when it comes to private actors. So what we argue is that it needs to be very much open source, but also that it needs to be constantly updated, and that we, as a community, as a society, and the institutions need to constantly supervise it. So in the last part, which is on the third question, we very much argue that there needs to be a process of supervision about what kind of results these algorithms produce. And you can only do that transparently if you have an open system, yeah? If this is not a private actor. So we talk about, before you unleash this into the ECHR or Geneva case law, you need to have experiments. How many violations is this going to produce? How many inadmissibility decisions? How many times would a human decide the same way based on the previous case law? Who is it biasing against, right? So one thing I'm currently working on is, we know that at the European Court of Human Rights, 80% of all the victims are men, right? There is almost no women victims. Why? Is it something about the process? Is it something about the judges? Is it something about the law? What's happening? Why are women, for example, not making claims? Or people, or members of minorities? So those are the things we need to be thinking about to understand what's happening now and what an algorithm could perpetuate. So I hope that answered your question. Okay, any other? So that's sort of the first thing, right? What would be the technical interventions into the system?
Yeah.
Now, in terms of the values, our feeling is, that there are a number of values that we need to protect in the human rights context. One is, this is a court of last instance, yeah? So it means that you will wait 7-8 years to get to it. There's no appeal to that decision. So if we bring in an algorithm at the last instance and there's no appeal, we better be sure it's going to make the right decision, yeah? So that's the freaky thing. This is a final decision. This is a last resort decision. The other thing is, it's a court that is deciding not about everyday things, but about major issues, right? These are big questions, and it's deciding for the whole of Europe, which means that whatever it decides applies in 46 countries of Europe. So that cross-border thing is super important. And that goes to your question, right? But some of this is domestic. So how do we make this work? So there are all these values that are involved in terms of finality, in terms of thinking about this is a human rights context, in terms of making sure that judicial discretion is protected, that it's still a human process, right? And that if these are human rights, they need to be about humans, not about machines, right? How do we do that? And then the last value we talk about is accountability. So how do you, in a system where a machine is involved, ensure this court and decisions it renders is accountable, right? Given that there's no way to challenge, there's no way to appeal. And this is where we really struggle. So if we introduce an algorithm into the process, it depends what it's doing. If it's just scanning this, fine, I can live with that. But if it has decided that my claim is inadmissible because it read 2 dates wrong or something like that, then I should have an option of challenging that decision. Which means we would be completely redesigning the system of human rights because we would want an appeal to come in, right? So that would be totally so that's a really difficult one. So we need to think about what accountability looks like at this level, at international level, as a last step. So what we suggest really is that we have accountability on a system level and on a case level. That means that in every case, you let's say as a victim of human rights, would get you would understand what the reason was that your claim was rejected, and whether an AI was involved and how they were involved, right? So you would understand that. And we believe, and what you would need to know as well on a system level is how the human was involved. So was there a human that checked for your decision? Yeah. Mm-hmm. And we believe that the human needs to be involved in that process, but not just automatically. So one of the problems we're seeing is that when we get a recommendation from AI, there are two groups of people. People who either accept it automatically and like it, yeah, that's fine, I agree with it, or people who disagree with it automatically, yeah? And they will disagree with it either because they don't want AI to take their jobs, because they're skeptical about AI, or because they are biased about the victim. So we saw in America, for example, policemen or parole officers consistently overrule recommendation of an algorithm based on the color of the skin of the person to be released. Yeah, so they will, when it's a white person who's due for parole and the AI says, do not release them, they will release a white person. When the AI says, release a black person, they will not release them because it's a black person. So you see, it's also about our interaction with how we react to the recommendation. Yeah? Mm-hmm. And so it really, like, if you're going to bring in AI, it's not going to be AI on its own that's going to be deciding. There's going to be a human here, right? And so we need to teach that human about how they react to that, so that they're not judging based on the blackness or the whiteness, mm-hmm. but that they're actually thinking, is this AI correct or not? Or how would I know if they are? So it's what we call automation bias. A lot of people will just accept what AI says, or they will just overrule it. They're not able to think about it. So we need to teach people how to think about what machines produce.
Analyzing.
Yeah, but also kind of understand what the algorithm learned from, right? What you gave it to learn from, and whether what you gave it was good quality or not. Mm-hmm. So is the algorithm learning only, for example, I don't know, Turkish cases or Italian cases, instead of learning from all the cases, right? Is it already biased, or is it only based on white people, and the moment it sees a black person, it's going to decide differently? So we need to teach humans we need to train them. We need to teach them not to believe it automatically or disbelieve it automatically, but to think about it, which means we need to teach people who are generally human rights lawyers to think in data terms. Yeah? To think about percentages, think about statistical significance.
But how can we do it if we don't see the logic process of artificial intelligence? Like when they take a decision, you can see how.
So that's really a really good question. So this is why we want to break the process into several questions. It's not just a question, is this a violation or not? Mm-hmm. But it's a question, was the deadline met? Okay, if the deadline was met, were the remedies exhausted? Okay, then if it's admissible, was the person tortured, or were they just in a 4 square meter cell? Okay, then were they with others? So you break it into lots of different steps, so that the algorithm is not really deciding about violation or not. Mm-hmm. It's deciding about the interim steps, and then it gets you to this answer that still the human needs to assess, does this make sense or not? Mm-hmm. Especially on big questions like climate change, questions that are going to change the law lots in the future. We need the human in there, but we need an informed, trained human, like this is going to be your generation of people. Mm-hmm. We don't want to have somebody who doesn't understand how computers work. So we need some data awareness. Questions? So if I speak to my colleagues at the moment, right, let's say my bosses at the court from like 20 years ago, they wouldn't know technology to the same extent as you guys do, right? And that's a good thing for where we're going, as in that you have the knowledge that they don't. So they wouldn't understand what it means to be statistically significant, or what is the data set from which an algorithm is learning. Like when I say the word data set to my colleagues from 20 years ago, they like don't know what I'm saying, right? But you guys already have a feeling. You know that ChatGPT is like not great, right? Because it's learning and then it sort of produces an average, right? So you already have a broader feeling of what data is, what is good data, and what is bad data, right? So it's really important for us to think in those terms and to be skeptical of that data because of what it produces. So for us, accountability is really important. We need to know how many times the algorithm has been used, how many times it's produced the wrong result. Yeah, we really need to know that. And how many times it was corrected by a human. And you know, this kind of decision making is already used by Facebook, by Meta, to remove content. Yeah, I know none of you are probably on Meta, right? But you're on Instagram, yeah?
Yeah.
Okay. So yeah. So Instagram, decisions about what is online, which one of your posts stays online and what is taken off, is not made by a human. It's made by an algorithm, which means that essentially some of those decisions are almost like judicial decisions about free speech. And what Meta is doing is trying to translate this legal equation into a computer equation. And so what we're saying, and what the oversight board in relation to Instagram has said, is we need to know how many times these algorithms are overruled by a human, how many times the computer gets it wrong, and why it gets it wrong. Is it something that you've put in the data set that shouldn't be there? And that's been the problem with Instagram, that sometimes certain things get taken off that shouldn't be taken off. Sarcastic things, things about political events, that they shouldn't be taken off because the computer doesn't know you're actually joking. Yeah, it doesn't recognize sarcasm. So those have been, for example, problems. And this is what we think about ECHR. So that's sort of what I wanted to give you a feeling of where we've been thinking about. Questions? Yeah.
So, for the future, we should expect to have like lawyers able to be expert, not just in the law field, but also in technology field, in order to be the supervisor of the accountability of AI, or you are suggesting that a new department can be connected to the law department in order to make it work?
So two things. One is what is developing now very much is that we are seeing programs being developed where you don't need to be a coder. You can, as a lawyer, tell. There's going to be computer people who are going to develop the code, but it's going to be, you're not going to need to code it yourself. So you're just going to say, this is what I want to see, and then it's going to adapt. So I don't believe it's great if you have the coding background, but I don't think the lawyers will need to be coders. What I do believe is really useful is to understand how an algorithm works, that it learns from what you give it to learn. It's not going to learn from like the air or I don't know. If you give it the convention, it can't do anything with it, right? Also, if it learns from the ECHR case law, the problem with that is it's not really learning from applications. You know, the problem is you get the judgments, yeah, But when you send the application, it looks completely different, yeah? So the only thing that ends up in a judgment is what the judges decided. And so they're two totally different data sets. Because a lot of people have come to me and said, I want to do an algorithm based on ECHR judgments. But that's more about classification of judgments into violations or non-violations. It's not really learning about how to recognize in an application what is a potential violation. Yeah, does that make sense? And so we really need to think that way, and that's what we need lawyers to understand. What the data set is, how that determines the outcome, and then we need to have lots of experiments where we test what a human would decide and then what an algorithm decides. And that needs to be constantly happening. It needs to be a normal thing, iterative, yeah? Over and over and over again. And finally, what we need to be aware is that if we're going to use algorithm, there's going to be no progress in case law. Why is that? Yeah, but yes, but in some sense, the algorithm learns from the past, and it's not going to make progress for the future. So if we want change, if we want progress from the future, we need to depart from, we need to make a conscious decision, right? So clima signorina would never have happened if we had an algorithm in the process, because it would have said, this is out. So we need to think about what are the important cases that we need to say, we don't use it here because we need this progress in case law. And that's even more important in the inter-American system, where all the cases they've got are the big cases. It's maybe less important here where we take every single case. But it's really important to be aware of the limits of what AI can do. Other questions?
So we can use like for a new topic like climate change, something that there is not like
we have nothing, right? We have nothing. And if you use an algorithm on admissibility in that context, it would just reject it. So we need to think about what are the important questions, what are the important topics where we shouldn't use it. Now, that can also be misused. Yeah, if you've got a political, case like Orban or like Erdogan, you can just say, oh, I'm going to let that go away. These things can all be misused.
So as a conclusion, you were saying how to say, to clarify the process where in the beginning the machines will specify or like how to say, the procedure applications or to reject them, like there should be human, like still, and like in the end, like it should be all being checked by human, like so.
Yeah, so and I think that goes back to your question. We find it very hard to say that a human should check, because usually humans are not able to actually process as much as information as the algorithm has, right? But the human should be there to think through what the algorithm has done, what it learned on, and to know from the experiments how many times this algorithm gets it wrong. So human is there to be an assessor of the algorithm's quality rather than do I agree with the answer or not. Yeah? Because if we ask, do I agree with the answer or not, we're going to have the parole officers in the US deciding on the basis of the color of the skin. But if that parole officer had been asked, how many times did this algorithm get it wrong in the past? So I'm not thinking about the whiteness or the blackness, I'm thinking about the computer. Then it would be a different question. This is why the thinking process changes. Yeah? But there are questions that are definitely easy questions that we can entrust. Calculate the damage amounts that the person should get. Calculate the dates. Calculate how long it has taken, to get from A to B. Is that relevant or not? Have they exhausted all the remedies? This is a case about, I don't know, Article 8. Does the margin of appreciation apply? What's the likelihood? 60%, 70%. That's already helpful, right?
Mm-hmm.
Precedent, I don't know. This is I can't think of a case now. This is like an Article 3 extradition case, suring applies. Those kind of things. That's already really helpful. And all of the proposals in this context are consistent with the AI Act because they're not about the very heart of the decision, right? The risky part of the decision that AI Act doesn't allow algorithms to decide. Yeah.
Which is the level of implementation which has been applied right now in the court? And also, I would also want to ask because I think in China, Japan, they are more computer-based institution.
Mm-hmm.
So, is there some way we can also be influenced by them?
So in terms of the level of implementation, the court uses some sort of content capture, the thing I described at the beginning. It does use translation. It does not use summarization. Judges don't like summaries. They like highlighting, but not summaries. The Geneva uses summarization already and translation. And it doesn't need content capture, and that's it. That's the current use. I know the court trialed to have a template of how to write a judgment, right? So that you would have a draft, but the algorithm wasn't very good at phrasing things in the same way as the court would, and so they dropped it. So they tried it out. So that's in terms of the court. At the domestic level, there are now experiments. Essentially, what we're being asked to do is to check, for example, by the Cour de Cassation, how consistent the decision of lower courts are, because it's important for the Cour to know where there's going to be a problem that is going to come up to them. Those kind of things is where algorithms are used. In China, they're much more used for small claims to make calculations, compensations, things like that. But it will depend. What we've seen is when in COVID times, all the processes moved online, is that became much better for victims, especially in the minority victims. They were much less, as in the results they got were better than when they had to appear in person, which is interesting. So some sort of technology has already affected outcomes. But domestic courts are going to be the first in this area to have algorithms. And most of the algorithms that I know at international level are currently used in Latin America. There they use them quite a bit to make drafts of judgments and to to cluster cases together in the same way as we propose.
Do you think that the use of artificial intelligence will shorten the period of the judgment within the European Court of Human Rights?
So that is the idea, right? So it's what I started with, the workload, but also the time frame. Yeah, that is the idea. I think, if we're totally honest, I think for judges, also the attraction is they all want to sit on the climate cases or on the, trendy cases. They don't want to sit on the repetitive cases where the same thing happened over and over again. So for them, the attraction is, can we reduce the workload? Can we shorten the time frame? But also, can we make sure to take the cases that we really want to and then delegate the ones we don't engage with? So like the one single judgments. But this is a very developing area, so let's see where it goes. Very developing. Okay.
I have a question, but it's not about artificial
Yeah.
intelligence, it's about you. Like, why you decided to study law, like in general, to make this career?
In law.
Yeah.
So I always wanted to be a journalist. I wanted to be a war reporter because I'm from former Yugoslavia where we had lots of wars. But then I watched lots of trials on TV and I really loved it. Like I felt that kind of, I loved argumentation and the way people. And then when I did the moot court here, the René Cassin in the court, I just thought it was the best thing ever. And so I really love the area of human rights. I think you can do a lot for people. I think you can really make a difference to people. And you get to work with some amazing people, so in terms of victims, but also activists. And it's really like it's an area that I just feel keeps on giving. It's a very hard area to teach because a lot of people are, they're disappointed by lack of progress in human rights or by, like at least, in the UK, there's a lot of talk about human rights being a Western concept. But I think there's a lot of good we can do. So that's what really drives me. Good. Well, it was lovely to meet you. Thank you very much. Yeah, I hope, to see you soon and to hear tomorrow. Okay, absolutely. But yeah, this is a very developing area, so.
We have some Moroccan sweets to
Oh,
offer.
lovely. Thank you.
One of us just come back from Morocco.
Amazing. Oh, wow.
Yes, just.
So do you usually stay here for like a few months or like the majority of people? Do people?
Yeah, it depends. But like for example, I stay here for 8 months, but the others like 6, 4, something like that.
But the core of the team is you.
Myself, the board member, we have other colleagues, but they are not here today.
And you have people also doing internships and things like that.
Internship, volunteering, receiving volunteer service.